Our next question is for our judges, and that is, what makes a good PTAB practitioner? And could you also share an account of a particular effective advocate or example of advocacy? Judge Quinn, can I start with you?
Yes, of course. Well, to me, it's, the distinction between good versus effective. I focus on, the practitioners that are results driven, those who are acting on the awareness of which are the fights worth fighting. Like you're wanting to win the war, not necessarily win every battle, and that you don't have to fight every single one to get the results you seek. And that comes not only with experience, but just having the clarity of what are the strengths and the weaknesses of the case, knowing the rules of PTAB, what the judges have a stomach for hearing. And like Laura said, the first thing we'll do is ask the parties to meet and confer and see what they can agree on, and something that makes it more efficient for everyone to get what they need to get to the end game, which is, let's see where the proceeding ends. And to have some awareness also objectively of how your case looks, because you have to be an advocate for your case, but you also have to have the clarity of what is the persuasive factor of all those issues, make lemonade out of the lemons, and try to put a puzzle together with pieces that are missing, and do so effectively so that we as judges, when we look at the work product you've put together, that we can then assess, apply the law to the facts. And I would say that, a lot of people focus on the fancy, the show of the oral argument, but we assess the efficacy well before that, from the very first paper that is filed, the petition. We read it cover to cover. We can assess there what are the issues, and for the particulars of which advocacy or which situation has been particularly effective, I would say for petitioner is those who are laser focused and understand what's the theme of their case. And you can see that from the beginning, from the first paper, from the petition, and this almost a surgical approach to how are we going to address all of this information, because it's a lot of information. So it's good to see the threads of a theme flowing through and being cohesive throughout a case. And the ones that are not so good are the ones that look like, spaghetti soup, everything on the wall and see what sticks. Those are not that effective. And yes, we can tell. So for patent owners, again, understanding what is the strategy and storytelling. Some of the best have been when they understand the adversarial process well, because it is an adversarial proceeding. But you have to balance that with also rebutting the other side's case, and understand that standing on the shoulders of who has the burden may not be alone what you need to carry the ball over to the finish line. And those who understand that and are able to gather evidence and persuasively argue their case, notwithstanding that the patent owner may not have the burden on a specific issue, shows us that they're very aware of the intricacies of an adversarial proceeding, and also the job that we have to do as judges.